And here we are. It's time for a post-election eviction hour. I'm Christian Walsh, real estate agent with Wire Associates, helping landlords and renters understand their rights before things go wrong. And I got my good buddies Raphael and Zachary here. Kenny is supposed to be here, and maybe he'll come in later. I'm gonna hold out. We're gonna stay on here until Kenny shows up, even if it takes 2-3 hours to do it. So this is a big one. We're gonna talk to the guys, these two attorneys from California Property Law Group. Kenny is here, he says. I just don't see him. Tell Michelle. Oh, here he's coming. He's coming in. All right. So we got Michelle in the background. She's going to be helping out, keeping things clean. If anybody's writing dirty messages, unfortunately, we won't get to see those because Michelle cleans those up. So anyway, once Kenny gets in here, he's turning on his camera. So again, remember, I can't give tax or legal advice. I'm dressed a little nicer than usual. I actually have a jacket on, but the guys with ties can. So Kenny better be wearing a tie so that we can differentiate the attorneys. So, guys, let's dive in. We got a lot of stuff to cover. First things first, most important question: how you dealing with this time change? Why is it friggin' dark already? Darn it! What the heck? And
I
how's
know,
it
right?
going with the baby, Raphael? And dealing
Yeah.
with
So speaking of the time change, she's been waking up about an hour and a half early every day. So, um, yeah. So this morning, she I guess thought it was 7 a.m. She woke up at 6 a.m. and go back to sleep.
how old is she now?
She's 8 months.
Okay, so 8-month-old, you cannot basically tell her that the time has changed. So, because I know it doesn't work for me, I can't figure out what darn time it is. So we're after the election, and so far so good. Oh, good. Kenny does have a tie on. That's good. Kenny, he's still getting ready. Let's hide Kenny. We'll let him continue to get ready here, and then we'll bring him in a minute. So we made it through the election. Thankfully, it was over quickly. It was like pulling a Band-Aid off for some of the stuff. They're still counting on other things. One of the things that was obviously very quickly figured out for those who are tracking it, besides President, was Prop 33. And we talked a lot about Prop 33. And what Prop 33 was going to do in the state of California was, if it passed, was going to roll back Costa-Hawkins and allow local areas to put rent control in place, unrestricted rent control in place, if a local municipality chose to do that. So it did not pass. In fact, I was surprised to see the numbers. Like, it wasn't even close. Like, everything else is closer than that. Zach, what are your thoughts? Why didn't it pass this time?
Yeah, it's
The third
broadly
time.
unpopular. It's failed multiple times in the past. I think that we forget that a majority of Californians are homeowners, and they saw this as yet another attempt to interfere with their property rights if they wanted to rent out. Most people who rent property are small mom and pop landlords. If somebody were to inherit a property, not be able to rent it out, or worse, inherit a property and then not be able to get it back, if their kid grew up or graduated college, needed somewhere to go. So I think that a majority of Californians have repeatedly shown that they're opposed to these kinds of laws. Uh, Maybe Prop 34 will pass, and this will be the last time that we have to deal with something like Prop 33, but somehow I doubt it. I think we might see it again. But so far, so good. Looks
Yes,
like, yeah.
what's interesting too, Zach, you bring up a good point about homeowners and not being able to actually use your property to its fullest extent, potentially under Prop 33. What was interesting too, so I did a video on it and it did pretty well. And basically, what I was trying to do was look at the bill itself, look at what was on the yes side to see if there was a good argument. Because as in politics, what happens is there's too much finger pointing, and it's like it's the fallacy of origin. It could be something good. It doesn't matter if it comes from a billionaire on either side. It could be something good. So anyway, long story short, what I found interesting is a number of renters who realized that by having much more strict rent control, it could potentially lead to less housing being built, which ultimately was going to lead to higher rents in the long run, which is Econ 101. I was very happy to see how many people understood that, whether they were a renter who theoretically, in the very short term, may somehow benefit from it. So anyway, long story short, that I was happy to see. Raphael, any thoughts on Prop 33?
No, I think you guys hit the hit all the points that I was going to say. I think that also, just to add, Prop 33 also had they raised double the amount of funding that uh, the vote against raised. So that certainly helped, I believe. And also, I think that the deciding factor is the fact that that it would that it would prohibit or de-incentivize people from building new housing, and that in effect would increase prices because there would be a shortage of new housing being built. So
100%. That was one of the arguments I was making, and in a few of the comments where I decided to jump in, it's like, look, right now, LA City has a problem. They're not building enough housing. They do have extreme rent control. They have the RSO for 640,000 units. They do have rent control in place, and we're going to talk about some of the new stuff they're putting in place. So, because people were trying to make the argument, the local legislators, they're not going to disrupt it. They're not going to pass something so strict that's going to disrupt housing being built. And my point was like, they're already doing it. They can barely get stuff built in LA. They've got billions of dollars through Prop HHH or whatever, and they still can't get it built. So, and that's what the law where it is now. If you got rid of Costa-Hawkins, it wasn't going to get better. Kenny, you're here. We're glad you're here. Thank God. You look good. You got a haircut, looking sharp. So what are your thoughts on Prop 33?
Yeah, I mean, I think that a majority of what you guys hit on was pretty on point. I think that without getting too political, I think kind of what you saw in the general election along with the other propositions kind of falls in line with where people are kind of standing on kind of like the policies that we've had in place for a while now. People are realizing that potentially rent control doesn't do what it kind of says. It tends to benefit a very small select few of people who have been grandfathered in into kind of somewhat ridiculous contracts where you're paying maybe $500-$700 for a 3-bedroom in LA City, and it doesn't really help the general mass or the rest of the people, because if you're grandfathered in, you're going to stay there forever and ever and ever and ever, and you're going to do whatever it takes to stay in that unit. Whereas other individuals who may not have that benefit are just going to have to pay the price for potentially more or less subsidizing those few selected grandfathered in contracts.
Christian, also, I did have some anecdotal evidence that apparently Prop 33 was phrased in a very confusing way. So I don't know, maybe people got confused and thought they were voting for rent control.
That's an excellent point, Rafael. Where it's the old, is a yes and no, or is it a yes? You could hit the nail on the head, because it should have theoretically been closer, in my opinion.
Yeah,
because there are a lot more renters than
and also on the part where it said people who are support groups that are against, on the ballot where it said who supports this proposition, who's against it. On the bottom it said, I believe, something about affordable nurses for affordable housing or something. Zach, do you remember what it said?
Yeah, I think it's called like the Coalition for Affordable Housing, something like that.
Right. So, who knows?
No, that's good. And here's a good comment from Paprika CDM, which is an exciting name. Rent control forces landlords to raise rents even though they don't want to. If it isn't raised, they fall behind. And that's been one of the side effects, to be honest, of even the Tenant Protection Act. If you don't use it, you lose it. So we're seeing rents going up because of that, but they are capped. And that was a big point in my video when I was talking about it, is it was being positioned as if though there isn't rent control at all right now, and that by saying yes, we were going to be able to have rent control. We do have rent control. We have extreme rent control in LA City, San Francisco, other areas that were grandfathered in before Costa-Hawkins. And then we have the Tenant Protection Act at a statewide level. And it's doing a pretty darn good job at keeping things capped. I know up to a 10% increase is a lot still. That basically doubles your rent. If you had a 10% annual increase every year for 7 years, your rent has doubled. But that 10% was essentially just because inflation was so high. We're already below 10%. There's nowhere right now in the state of California, if I remember correctly, where you can actually go to 10%. So, all right. So having said that, let's first talk about what's going on in the courtrooms. As I always like to ask you guys, because you got the boots on the ground, what do you guys have to report? Anything new and exciting in the courtrooms that you're seeing?
Yeah, I mean, I guess what I wanted to comment on is it's a lot of the courtrooms are actually, depending on where you are, they're trying to accommodate the jury trial demands. Now, I'm sure that everyone's been aware that jury trial demands, they're not like it's a new thing. It's been around for quite a while, but they've been ramping up quite a bit since the past maybe 4 or 5 years ago. And, when people say the gears of justice move slowly, this is kind of what I'm talking about, where the courts are now realizing, oh, okay, we actually need more judges. We need to be able to get more jurors to be able to hear these cases, to get them off the docket. And a lot of the actual UD hubs, they've been basically assigned to keep their jury trials and try to have them adjudicate them with the jury trials. So you're seeing a lot more, I guess, in-house, I guess you would call it, jury trials where some of them are keeping them in the actual hub. And hopefully that'll speed up the actual process of getting the jury trials actually heard.
What does that
Um,
mean in the hub? You're talking attorney to me right now. Dumb it
so
down.
there are certain depending on where your property is, the lawsuit or the eviction case will be filed in a certain area, and certain courtrooms will have more judges available depending on the size, the population, how many cases are being filed. And they're realizing that these jury trials are causing quite a lot of delay, but they're only realizing it, 4 or 5 years after it's become a problem. So now they're slowly starting to realize, okay, we need to actually get these judges to try the cases. And they're slowly starting to make policies that would make it better, or at least somewhat faster, to get someone in front of a judge and actually hear the case. That's basically the end that I've seen from judges and courts in LA County. Um, when it comes to actual eviction law, or when it comes to actual um, policies that landlords can follow through with, one thing that I've been noticing more and more of is the phrase accidental landlords. And the issue with that is that, where, let's say that somebody either inherits a property or decides that they want to move out of the property they've lived in themselves as actual homeowners, and then decide, well, what am I going to do with my property? Well, maybe I should rent it out. And without any prior experience, you're going to get killed. You're going to get killed in California. Not because you want to, not comply with the law, but just because there are so many laws out there. There's a lot of regulations, and it's really hard to kind of figure out which rules or laws you're supposed to comply with. And a lot of landlords, when they say, "Hey, I want to do this," or "I want to do that," they don't really follow through with the basics of the business itself. And I've run into a lot of landlords who I've seen who either don't have a ledger, don't know what that is, don't keep a record of payments, and that on a basic level is going to be really painful. Or even keeping records of rent increases, or notices to tenants. These are all things that landlords need to hold on to protect themselves. And as tenants as well, if you don't keep records for yourself, you're also not going to be able to prove your case. So on both sides, everyone kind of needs to keep cleaner records. They need to kind of treat this as a business, because the state of California is going to treat it like a business, and they're not going to have any sympathy for anyone that comes to their courtrooms.
That's well said. And that's the accidental landlord too. And you guys mentioned briefly inheriting a property. That happens too, where I've been dealing with several clients right now who inherited properties, and there are literally no records whatsoever because they weren't keeping careful records. Mom or dad basically was just running it, running it like a mom and pop. And there were bigger fish to fry than kind of keeping all that paperwork sorted. And so now they have no paperwork. And one more important and fun thing with inheriting a property is they're getting reassessed because of Prop 19. So their property taxes are going up, and they're being reassessed at crazy high numbers. I have a listing right now in Pasadena. He was reassessed at $1 million for this property. And talk about rents being low, and what we were talking about before, it's the rents are 800, 800, and 950. It's a 2-bedroom, 1 bath. Those are 800. So his property's not worth anywhere near that, et cetera. Now we're trying to sell it, and we've got no paper trail at all. So that's what I do. I come in and help take care of that, and I've got you guys as backup as well. But you're 100% right. The accidental landlord through inheritance is very tough. Zach, what are you seeing in the courtrooms? Anything fun? Can't
Hey, hear
hear you,
me?
buddy.
Sorry,
There
there
you
we
go.
go.
Got you now.
Seeing a lot more people. I don't know what it is in the valley. A lot of people that are renting out like a garage or some kind of commercial space for people to live in. Really got to be careful about illegal units in LA. Really got to be careful about what you're renting out and who you're renting it out to. Seen people who, a friend really needs a place. Okay, you can stay in my guest house, only pay a couple $100, only to get turned around and sued. See sons suing mothers, mothers suing sons, people who otherwise you'd think would be able to get along. Yeah, people will turn on you. So be careful what you're renting out and who you're renting it out to. Be really, really, really careful.
And Raphael, you've been traveling, so you don't know what the heck's going on. No, I'm just kidding. Anything to add to that, bud?
I guess we've been starting a lot more evictions based on people trying to remove their single family home from the rental market and just sell it.
Yeah.
So maybe we're just in the business and we get to see only the landlords who want to get out of the business. But it's just weird, like trend that I'm getting a lot of these calls that people want to remove their property from the
because I'm sending them to you, by the way.
Maybe
they're calling me and they watch our lives and they see and we're starting to get some questions. I want to jump into the questions, but that's one of the things. So LA City, for example, is talking about right now, and maybe we'll get to it, depends on how much time we have, but they're getting rid of one of the no fault reasons to terminate a tenancy under a substantial remodel. So a landlord, right now, under state law, under the Tenant Protection Act, if a property is subject to the Tenant Protection Act, a landlord can do a substantial remodel. If the renter is going to be out for 30 days and the landlord delivers the permits ahead of time, they can terminate the tenancy, fix it up. So LA City is going to remove that, not allow that. So they're getting rid of reasons. They're getting rid of ways for landlords to, number one, fix up their properties, but number two, sell their properties if they don't want to be landlords. So they're only going to be able to use what you said, which is removal from market, until they close that loophole, and basically people are forced to be landlords. So, and accidental landlords, like you guys were saying. All right, so we got some good questions. We'll pull these up and keep going. So Adam's asking about how should landlords handle tenant requests for accommodations, such as an ESA, an emotional support animal, if you believe it to be fraudulent? And
So-
I mean, we haven't. Someone chimed in to say it doesn't matter if you think it's fraudulent, but yeah, if they give you a letter from a doctor, what can you do, even if you think it's made up?
Yeah, so for ESAs, I would definitely say you need to be careful on those. That some of those have turned into hundreds of thousands of dollars lawsuits that I've seen for landlords who had just decided I'm just going to ignore it. Essentially, the law is very favorable for individuals and accommodating for people who need emotional support animals, and the barrier to it is not very high. All you really need is a doctor's note or a social service worker's note saying that this person needs a emotional support animal, and the landlord is then basically barred from charging additionally for those emotional support animals, and you have to give reasonable accommodations for those emotional support animals. And failure to do so is going to set yourself up for liability and potentially getting sued in a separate civil case over that. So I would be really careful if you receive any kind of request for an accommodation for an emotional support animal.
Another important point to add to that. Thank you for that, Kenny. That was great. Another important point to add is that there can't be breed restrictions for emotional support animals. So, for example, if there's a pit bull and your insurance as a landlord says you can't have pit bulls, they will not cover damage from pit bulls. If you have an emotional support animal, you have documentation, you are protected as a landlord if that pit bull does end up causing damage, and you can get coverage. So just something to add in there. There's some more good stuff. Samuel, I like this. Samuel says, you're all dressed up today. Celebration of Prop 33 going down. Bring the champagne. So the truth is, they always look like that. I'm the only one who dressed up a little bit. And yeah, I'm happy Prop 33 didn't pass. because for me, I just want more darn housing. That's really all I care about. And it was going to make it much more difficult in the areas that need it the most. They were going to make it the toughest. So anyway, that's good. Samuel has a good question here related to rent increases. So if we look at San Fran's historical rent control adjustment from full CPI at inception. So in other words, the annual rent increase was allowed to be full CPI. Now it's 60% of CPI within 10 years. So there's been a shift in the number that's being used for the rent increases. Is there a precedent or likelihood of a similar adjustment to the Tenant Protection Act? I'll give my thoughts and then you guys can dive in. So we are seeing that, for example, in Santa Ana, who has Measure CC on the books to for everybody to vote on keeping their rent control there. Even if it loses, they keep their rent control. They're at 80%. It's 3% or 80% of CPI, whichever is lower. That's the annual increase. So I don't see that happening at the statewide level, the Tenant Protection Act. The Tenant Protection Act to me was kind of a perfect, like everybody was working together. People looking out for landlords, people looking out for renters. Everybody's trying to come up with a rent control bill that kind of met in the middle. So I don't think it's going to change. And it's good through 2030. So they could modify before 2030, or we could see a change after 2030. And I mean, knock on wood, hopefully the CPI stays low so that we don't have to be going at a percentage of it. Hopefully we keep it 3 to 4% for CPI. And if we're going to use that number, then that's an easier number to chew on. Nobody, maybe it's just me, nobody thought CPI was going to get as high as it did, as quickly as it did. So that's kind of, none of us at least in my lifetime, are used to numbers like that. So anyway, your thoughts, guys, on rent increases and CPI?
Sorry, I muted again. No, I totally agree. I think they asked statewide. There's no way. I think that a big part of why California is, to my understanding, the only state that has statewide rent control. There are most states not only do not have statewide rent control, they prohibit rent control at the local level too. They have absolute bans on rent control. If you go outside of the United States of America, it's extremely rare to find rent control. So yeah, California is kind of ground zero for rent control. And I think that the Tenant Protection Act, or AB 1482, represents something of a compromise where the rent cap is generally non-binding. So most landlords, most years, are not going to be raising the rent the full amount because the market isn't growing that quickly. So you have landlords who, for whatever reason, might like hate one particular tenant and want to jack up the rent by, thousands of percent or whatever. The TPA helps curb some of the worst abuses without really impacting the day-to-day operations of most landlords who are behaving normally. So I think that's a good place for it to stay. I don't think it would make sense to try to sort of engineer cheaper housing through price caps that are really severe. I mean, they had that during World War II. It was just really, they had that in the Soviet Union. I mean, it's typically not a good long-term solution to housing shortage is to impose price caps. It doesn't do what you want it to do. So I think the TPA is here to stay, and mostly in its current form.
Yeah, I agree with you. How did it work out for the Soviet Union? Was that a path to success by capping those rents?
It got them to the moon. And then, yeah, I mean,
well said. We went to the moon without it too.
They got a rover on the moon. They got a man in space, and they got a rover in the moon, and that's basically what they got out of it.
All right, Sam has another good question. Which governing bodies or legislative processes determine how these rent control measures are adjusted over time, and how might property owners influence or stay informed on potential future changes? So great question, and it's the local municipality. So for LA City, it's the LA City Council. So what you're going to want to do as a landlord is you're going to want to go to LA City Council meetings and show up. And we talked about this at the conference we just did together. We had a panel at the AAOA conference, and we talked about getting involved. So landlords need to show up, show that you're not just a greedy billionaire, and show that you're a real person, and help influence policy where it's headed. It's only a few areas that are implementing rent caps that are more strict than the statewide area. They're statewide caps. So it's LA City, Santa Ana. You just got to keep an eye out and join an apartment association like California Apartment Association, AAOA, AAGLA, AOA. They'll keep you up to speed as well on who's talking about changing, making rent control more strict. Anything to add, guys?
Yeah, so I mean, I think that's the reason why there's always advocacy for local grassroots, movements, because the biggest change you're going to see is at your local level, which is like your city council, your mayor, things like that. And then you go upwards from there. You go to the county level, you go to the state level, you then go to the federal level. But most of the interactions that you're going to get with rent control are going to be at the local city level. For your mayor or your city council.
Yeah, and I'll show you too. So the CAA has a news page, and if you're subscribed, you can go ahead and read the whole article. But just if you go to their news page, it keeps you up to speed and tells you in a headline kind of what's going on. So LA County is approving a stricter renter cap, for example, so you can stay abreast that way as well. So, all right. So good question, Jim. We've got Jim asking about the emotional support animal. So if your insurance doesn't allow a certain breed that a tenant has, is that a reason to deny an ESA? No, you can't deny the ESA based on breed, and your insurer cannot restrict you from having an emotional support animal of a certain breed. What about the guys? What do you think about the emotional support alligator that was legitimate? How does a landlord have to accept that in LA or in a urban area? Any thoughts on that? How do you get around that one?
So normally what you want to do is, I think that the standard is that it would work a total change in the program that you were offering. So if, for example, as a result of you having this alligator or something like that, you couldn't have any other tenants in the building except for this one that with the alligator, that is okay to reject. But you do have to go through what's called the interactive good faith process to try and figure out if there's a way to resolve the issue by accommodating them. And yeah, I've been waiting for like emotional support spiders or emotional support cockroaches, emotional support. I think you could have an emotional support rat maybe. But yeah, it really is. It is hard to overstate how powerful these anti-discrimination laws are. They override private contracts. They override zoning laws. They override just about anything you can think of melts in the face of these things. But with that being said, anytime you have something that's going to work a total change in the program that you're offering, you can feel free to reject.
So the emotional support rooster that I had a client who had, one of her tenants had that. The judge did rule in the landlord's favor because the rooster was disturbing everybody, the quiet enjoyment, because, well, roosters do what roosters do in the morning. So the landlord didn't have to let them keep the emotional support rooster. That's a true story. All right. Raphael, you're awfully quiet. Anything to add about emotional support animals? Or fair house?
No, that's actually the area that I always defer to Zach and Kenny on.
So that's what I like about you guys. You have your areas of specialty. Zach and Kenny, what do you defer to Raphael on? How about that? Put you guys in this hot spot.
Raphael's our trial attorney pro. He wins every jury trial he goes on. He's one of the best jury trial attorneys out there.
And what is Zach known for besides history of the Soviet Union?
He's a walking encyclopedia, basically, as you can tell.
If you want a history lesson, he'll give it to you.
Whether you want it or not, whether you want it or not.
And then, you ever give a judge a history lesson, Zach, or no?
I stop myself. There have been times where we've started like kind of geeking out over, medieval writs and different distinguishing, and it's just like, you know what? I'm not doing this in front of everybody. Like I'm just gonna be quiet. But yeah.
I love how dorky you are. That's perfect. All right, so this is Jim, and I know Jim here. He's talking as a private money lender who's foreclosing on a residential fourplex. The property reverts to me as a lender and now landlord. Can I evict all the tenants, or do I inherit their leases? I'm going to give you my 2 cents and let these guys step in. But yeah, if they are under active leases, so there's, for example, 6-9 months left, you do have to honor those leases. You could attempt to use cash for keys to buy them out of that. If they are month to month, based on my understanding of the law, you have to give a minimum of a 90-day notice under the foreclosure laws. But I defer to the pros. What do you guys have to say to this?
So this is always going to go back to where are you, and is there a local rent control ordinance or just cause protection ordinance that also affects this building as well? So if you're trying to evict someone that has a valid bona fide lease, you're going to have to still subject yourself to any local rent control ordinances that may protect the occupants inside.
Unless they might all be related. So in that case, you could evict them if essentially everyone occupying each one of the quadplex is a relative of the owner, and there's no real lease, really.
Yeah, so it's not arm's length. So it needs to be arm's length, is what you're saying, right, Raphael?
Right. Correct.
Okay, that's good. Good to hear. So another good question: can the tenant buy renter's insurance to cover dog bites? You can require that a tenant buy a certain amount of liability insurance. I don't know if they cover dog bites, but any thoughts on this, guys? And could you do it? You couldn't have a special policy necessarily for ESAs, right? You'd want to just be across the board. Just say, hey, you have to have $300,000 in liability. What do you think?
Yeah, no, I don't want you to have a special, like, if you're going to have an ESA, then I'm going to charge you more. I'm very uncomfortable with that. You have to rent to them more or less on terms of equality with everyone else. And so equality here doesn't mean, well, you can pay for the animal yourself. It's sort of like at the landlord's cost, they could be required to, for example, build a wheelchair ramp, something of the sort. And in the same vein, they could be required to, more or less cover the liability, or risk the liability for this animal. So I wouldn't want anybody to impose special conditions or restrictions, financial conditions or restrictions just on disabled tenants.
Yeah, and just to add on to that,
Sure.
I do want to point out for the ADA laws or for the ESA laws, a lot of landlords try to look at it from a perspective of, well, I'm not the one that requires them to have it. They're the ones asking for it. They're the ones asking for an accommodation. And the thing that you have to take a look at is that these laws are meant to protect people to have equal access to the actual program or to the actual venue itself. So I did have some people say, well, why do I have to build a ramp at my cost? I didn't put that guy in a wheelchair. And it's not like, no one's saying that you did. But what the law is saying is that that person, in order to be able to equally access, to have equal opportunity to be able to use that building, unfortunately needs a ramp. So that responsibility then is pushed on to the owner of the premises, who then has to comply with the law and saying, well, the only way that the person with the wheelchair that can access it would be if there's a ramp there.
Thank you for clarifying that. Yeah, the question was related to an ESA for that. So yeah, I do believe that the insurance, so like if you got renter's insurance from Lemonade, for example, not a sponsor, just easy to get insurance there probably is some coverage for dog bites. So I would recommend as the renter, you look into that to protect yourself, because if your dog bites somebody, it's going to cost you money. So and I will tell you, even if it's an ESA and it's your ESA, even if it's a service dog and it's your service dog, so I knew of a case where it's a highly trained service dog ended up biting somebody, theoretically, or that's what the story was. So the renter got evicted because of that, and blah blah blah. So even if it's a highly trained service dog, you still may want to have protection for yourself. Samuel has a good question here about shenanigans. I just love saying shenanigans, and this is a good question too. So how familiar are judges with common tactics or shenanigans that tenants might use? And I think the bigger question is, do they care when the tenant uses it? I know they know what you guys are up to with shenanigans, and they have probably no patience for attorney shenanigans. But how about tenant shenanigans?
Um,
And here's an example of one: submitting a habitat complaint while also being late on rent.
So basically, as long as you're following the problem is that a lot of the quote unquote shenanigans that tenants are using are actually real rules under a civil code, on the California Code of Civil Procedure. So, for example, filing motions that we might deem to be baseless. So, for example, filing a demur to a complaint, right? Which it's a judicial counsel form complaint. We just fill it out for and file it with the court saying that the tenant owes rent, so we're evicting him. That a lot of landlords, when I explain to them what it is, they're like, "Wait, that makes no sense." Because what a demur does, it's essentially challenging the validity of the complaint, right? Saying you don't have, even if everything you're saying is true, so what? So you have no case. But it's a judicial counsel form, and it's more every single time it's an eviction, right? So when I explain to the clients that the tenant has filed a demur, saying we don't have a case, they get confused. They said, well, the judge is surely gonna be upset at the tenants, right? And majority of the time, the answer is no, because I don't know why, but probably it's because they're pro pers, and
What does that mean?
Pro per means they're self-represented, and also they're not technically violating any law. They're allowed to use these tools of civil procedure to delay the case if they want to, and actually sometimes even attorneys do it too. So I don't think it really upsets the judges. Maybe it does, but maybe sometimes it does upset them, but they just don't really act on it. However, in certain cases, you will, if an attorney does it and it's borderline unethical, you could always get sanctioned for doing stuff that's that's not in conformity with the law, or if you're just outright abusing the civil procedure process. So
when you say that outright abusing the civil procedure process, you as an attorney have a much higher bar, pun intended, passing the bar. But
just to add on to that really quick
pro
as well.
pers, you don't. You can get away with it if you want to play. Go ahead, Kenny.
Yeah. When it comes to, I guess, shenanigans in court, it kind of boils down to whether or not people think that what someone is saying is true or not. And a lot of the times, people have the rights to be heard at court, and they have the rights to a trial. That's kind of the fundamental belief that a lot of Americans have, where it says, I have my day in court, I have the right to be heard. And sometimes, if you've ever seen people talk, people say some dumb stuff. People say some stuff that just makes no sense. But everyone has the right to say that. Everyone has the right to be heard. So I've seen people at trial say things that are just, borderline nonsensical. But they have the right to say that. And unfortunately, unfortunately or fortunately, our justice system allows people to have their day in court and say what they want to say. Now, some people do see the writing on the wall and say, well, I don't have a defense. I'll just, resolve this case in a normal fashion. And other people really legitimately believe that, well, if I say this, I'll be able to win the case. Or if I say that, I'll get this one over on someone else. And so it really does kind of boil down to, who's in the unit, what kind of, brain do they have on their head? What kind of head do they have? Are they really thinking about their situation? Are they really kind of balancing all of the facts and trying to come to an actual decision that makes sense? And a lot of the times, people will just say whatever's on their mind, and the court lets them do that.
Zach, what's the craziest thing you ever saw a tenant pull?
Tenant. There you see a lot of the same stuff.
7 bankruptcies, Zach. You remember that? The 7 bankruptcies.
Yeah. It's like, so there are certain kinds of shenanigans that if you pull, judges immediately know, okay, that's what this is. There are people out there who are gray paralegals, people who engage in the unauthorized practice of law, who represent themselves as, I'll delay your eviction if you pay me X $100. And they typically have certain kinds of patterns that they employ to delay the eviction. So one is serial bankruptcy filing. You'll see that a lot. Another is federal removal. So you'll say, oh, this case belongs in federal court. And so it'll go up to federal court, and federal court, they're on the hunt. They find these cases and kick them down. But if you file your removal the day before the trial, well, then the trial can't go forward because it's in federal court, right? Of course. So there are a number of strategies that pro per litigants will employ that some with different levels of sophistication. I mean, I saw one person who was a pro per litigant but was an attorney but was representing themselves because they were facing an eviction. They delayed a case by like a year and a half through a really nice appeal and stay pending appeal of like an interlocutory motion. It was a masterclass in delay. I really have to say, guy lost, and also was subject to disciplinary proceedings. Did not work out for him. But just as a pure, like, kind of, okay, win the battle, not the war, masterclass. I mean, an unbelievable amount of delay. Yeah, lost his license. But yeah, what a ride. Must have been one really sweet unit because he wanted to stay, did not want to leave.
I heard of a guy who beat the Irvine Company for a year, which Irvine Company is the biggest, one of the biggest property owners in Orange County, and they have a team of lawyers, and he was able to stay for a year. So he was doing well with his delay, and that's a good reason to bring up hiring you guys. Having you guys as professionals, you guys will help make sure the process moves along as quickly as possible. Because me trying to represent myself pro per as a landlord would be, I mean, you don't know what you're walking into. So that's why.
By the way, Christian, the cases that are the most susceptible to shenanigans are foreclosures, because the homeowner has already kind of ruined their credit at that point, and they're willing to go as far as they can to stay there.
Yeah, well, and we'll have to talk about foreclosures in one of these, because there's some new laws coming in 2025 to extend the foreclosure process if you show up with a listing agreement, and then to extend the process if you get a contract, you can extend the foreclosure process. And then there's, on the other side of it, the SB 1079 after the foreclosure process. There's some crazy shenanigans going on with that whole thing. So anyway, we'll have to talk about that. That would be fun. So this is a good question here. How can we find a shark tenant attorney that would make you guys shake in your boots if you're wearing boots? I know there really are some very good legal aid tenant attorneys that I've talked to and have been able to make life miserable for landlord attorneys. Any advice on where to go for a good tenant attorney, guys?
Are we going to plug one of our opponents?
That's true. That's true. You don't have to give names, but yeah, there are a few. You guys introduced me to your one buddy that does that. So, but maybe buddy's loosely used there.
I would say the best thing you can do for your case is by actually having one as a tenant, because technically the way the law is designed is if you do everything correct as a landlord, you're supposed to win. And the shark tenant attorney, I guess, would spend a lot of time on your case doing discovery and depositions to try to find a way to find something in the case that the landlord's attorney did incorrectly. So
should a renter hire a paralegal to try to help? I've heard some horror stories from the renter side where they pay somebody $3,000-$4,000 saying they're going to be able to keep them in their place, and they can't. So any advice to that?
So one thing you could
terrible idea.
Well, just one thing you could do to make sure that you safeguard yourself is ask for the attorney that's going to be representing you. And then if you go to the California State Bar's website, you could search that person and see if they are a licensed attorney or not. And if they are a licensed attorney, the State Bar website will also tell you if there are any disciplinary actions against them. So you could definitely check there and see, should I hire this person who has a record of disciplinary actions, or should I hire this other guy who doesn't have those records?
Well said. Same thing with real estate agents. If you've got a real estate agent that's got a bunch of actions against them, you can go to the BRE. Well, they keep changing the name of it. It was the DRE or the BRE, one of the two. You can search and see if there's action against real estate agents. Hey, here's a plug for you guys. Hired you guys as a landlord, and you guys kicked a star. Good job, you guys. Good job. That's why I always plug you guys. Let's see. This I thought was a good point here. Remember we were talking about the ramp and accommodating a ramp? Do good when the landlord may need a ramp, right? You never know when the shoe's going to be on the other foot. So that's I think that's good advice right there. All right, so Paprika has 3 questions. We're going to go through this. Tenant regularly gets late fees but doesn't pay them. What is the proper form to serve to make them pay? That's question number 1. 3-day pay or quit, or what? What do you guys say?
3-day perform conditions and covenants or quit. Technically, if you're doing a 3-day pay rent or quit, rent is rent is rent is rent. All other financial obligations, 3-day perform. So you need to perform the covenant or quit. If you're subject to the TPA, that's the Tenant Protection Act, you then have to serve a second notice afterward, 3-day notice to quit. Okay, so look at your local jurisdiction. It might not be a 3-day in some places. For example, in Santa Monica, it's a reasonable time. In unincorporated LA County, it's a 10-day. But generally speaking, you're talking about 3-day, perform, or quit.
So the real answer is hire Zach to do the paperwork for you. That's the actual answer there, to make sure it's done right. All right, Paprika is signing up for RUBS. That's Ratio Utility Billing Services, to have the tenants pay for some of the utilities. Is this fee essentially part of the rent when calculating the rent?
That's going to depend on where you are as well. But generally speaking, I'm going to say no. I'm going to say utilities and rent are totally separate. So if you're going to switch them over and they've got to pay the utilities, you don't use that to determine whether or not you're going to be at your cap for the TPA. And likewise, you're not going to use that to determine if you're exempt from the TPA, if you're going to be doing a 30-day notice or a 90-day notice for more than 10%. But it might change depending on where you are.
That's what I was just going to say. Just remember, for example, if it's an RSO property, as far as I know, you can't be using RUBS. Wasn't anybody impressed that I knew what RUBS, ratio utility billing? Nobody's like, hey, look at that guy. He knows his stuff. No. Right.
You can't. Hey, hold on. So for RSO, for RUBS, you can use it, but you have to give them a corresponding. So if you're going to give them the utilities, you got to do a rent decrease, and they have a formula from the Rent Adjustment Commission that'll show you how to calculate that. So you're ultimately not. You're going to render yourself less vulnerable to like really high utility bills, but you're not on average going to be making any money. So that's why a lot of people don't do it.
That's good. Very good point. Yeah. What's funny is people say, oh, I want to add a fee to the above and beyond the rent to cover the cost of water or whatever it may be. But then the renter uses more because they're like, hey, I'm paying for this now. I need to get my extra $50. So it ends up costing even more. So I just tell people, in some cases, unless it's extreme, if they're running a laundromat out of there, that's something different. And then this is Paprika's 3rd question. They've completely destroyed the tenant, destroyed the garage door. They're demanding a new door and motor. Door's 11 years old. The other 3 doors in the building are installed at the same time and apparently are fine, are all in good condition. So any obligation here? What are your thoughts?
So this is kind of like the situation where you find yourself with habitability claims. Normally, if a door or a window or something is broken, the landlord has an obligation to fix it. The only time where it doesn't kick in is if the tenant is the one that caused it to be destroyed. The problem with this is that you're going to have to prove it. And a lot of the times, if you just say, well, who else is in there? It's just them. That's circumstantial at best. If I said, hey, like, who else is normally there? Oh, I don't know. It's got to be the tenant. That's not a very strong case to prove that the tenant did it. Now, you might convince some people, but are you willing to bet a huge lawsuit over convincing a couple of people over that? So you kind of really do need solid evidence. You need to be on solid footing to be able to prove that the tenant did do it. And from my experience, what I've seen, a lot of landlords kind of fall into this camp of saying, well, who else would have done it? And that doesn't really quite get you there. What you kind of want is eyewitness testimony, or someone said, I saw him take a hammer and break it down. Or if you have a video of him taking a hammer and breaking it down, even better. But this idea of just saying, well, who else would do it, doesn't really fly in court, and it's not a very strong case. So unless you're certain that you could prove that the tenant was the one that destroyed the garage, I would take steps to try to work and negotiate with the tenant and saying, okay, well, how did it get there? Maybe we could work on the cost of it. But if they're adamant that you pay for it, and you can't prove that it was them, I would take steps to protect myself and maybe eat the costs of repairing it, unless you're certain that you can prove that it was a tenant.
Well said. Raphael, anything to add to that?
No, absolutely, Kenny. Kenny covered all the points. I will just say, if you cannot prove the case that the tenant actually is the one who damaged your garage door, then think about it like this. What if, God forbid, there's a robbery and someone's able to break in due to the damaged garage door? Then you're going to have to deal with a lawsuit, right? So, hey, landlord, you were put on notice to fix a garage door. You didn't fix it. And I got robbed and I got injured. Now I'm suing you, So, I think sometimes you're just better off fixing it, even if you know that the tenant is the one who broke it. But you gotta be reasonable about it. Obviously, if it's tens of thousands of dollars, then you might not want to do it. But if it's a couple $100, just go ahead and fix it. That's what I always say.
That's a great point. Get it done. Get it taken care of. Like, I'll have landlords come to me, and of course I pass them on to you guys. But they'll want to terminate a tenancy, and there's some health and safety issues that need to be taken care of. So I always tell them, hey, get that leak fixed under the sink. And then we give a notice, a 60-day notice, and the water heater goes out day 30. Hey, sorry, you got it. If they're still in possession, even though they're going to be out in 30 days, you still have to change that water heater. So that kind of stuff dovetails into what you're saying, Raphael. So Carmen, who is a fan, and I'm a fan of Carmen, she's here often. So she's got a long story. We're going to race through this. She is a real estate agent like me, and she doesn't do evictions because, well, we can't do evictions. You guys do it. So what she did, though, I was reading through this. She had an issue where she advanced the fee for the cost of the attorneys instead of having the landlord pay it. And it ended up not working out so well. So it ended up being a case where eviction went wrong. A 3-day paranoid notice. I like that. Anyway, long story short, Carmen, this is a long one. We'll keep going real fast. Seller got upset and took away the listing, and she never got refunded on the work that was done. So this is why I think that the couple points here. One is hire these guys, and I know Zach wants to read through this. Never advance, and this is it right here. So number one, hire true professionals, because just because they do a lot of evictions, or maybe they don't do any evictions, doesn't mean that they're the right person for doing this eviction. But that's why I use these guys, because they are honest. They'll tell you if you have a case up front. They're not just going to try to get money from a property owner, or in this case, from an agent. So yeah, I agree with you, Carmen. I sell a lot of tenant occupied properties, and I refer a lot of business to these guys. They're worth every penny, but I would not advance the fee. That's going to be a fee that the landlord is going to have to pay, part of the cost of doing business. So thank you for sharing, Carmen. Is it true that low-income tenants can have free representation in eviction court?
Yep, absolutely. Happens all the time.
Legal aid. Yeah, legal aid.
In fact, I think almost very soon, every tenant in LA City and LA County will have a free attorney. We're headed that way.
I remember we talked about that, and I was wondering where all the attorneys would come from. Where did you guys say that there are trains of attorneys on standby?
Yeah, there's. I have a friend on the other side of the bar that is waiting for this.
How many sides are there to this bar? And are we talking the real estate bar? Or are we talking a bar now? I don't know.
Someone who primarily only represents tenants.
Okay.
So yeah, so he's anxiously waiting for this,
and they'll get paid, right? They're not going to be doing it for free,
right? And he'll never have to spend a penny on advertising. So
I mean, the government is trying to pay for it from Measure H or whatever, but whatever money is fictional or made up from the government, they'll appropriate money wherever they can. Maybe raise some more taxes. Who knows?
Kenny, why are you being so pessimistic about government? Come on. They know how to spend every dollar correctly. Okay, so we're almost to an hour. These always go by so fast. I love talking with you guys. So we got about 6 more minutes. So we're gonna race through a few more, and then we're gonna talk about why you guys are so awesome. So on this one, the free representation in eviction court. Somebody asked about small claims or attorney. You can't have an attorney in small claims court, so you got to represent yourself.
I
And
think
small
that was,
claims. Go ahead,
sorry,
Raphael.
cut you off. I think he was trying to ask that. That question came in when we were talking about the late fees, I believe.
Got it.
Yeah.
Okay. Let's see what else we got here. We'll race through. Where can I verify whether the building is up to date on licenses? So which license are we talking about? Are we talking about like an RSO, like registration license? Or are we talking permits?
Yeah, if it's permits, most cities will have their own Department of Building and Safety. That's where you're going to be applying for things like certificate of occupancies. That's going to determine the actual use of the building itself. It's going to comport with zoning laws within the city. So depending on where you are, you might want to check out the Department of Building and Safety of whichever city you're in, and that'll tell you about if you have a valid certificate of occupancy or if you're using the unit in a legal way. That would be for that. But if you're talking about licenses like Christian, you were saying about registering your units with a rent control board, that also is going to be city dependent. For LARSO or for LA rent controlled units is going to be LAHD. They've also changed their names. If it's unincorporated LA County, you're going to go to LA Department of Consumer Business Affairs. So again, it's always location. Where are you?
And you can look them up online for LA City. You can look up on the LADBS website. They've got it online. Likewise, for rent stabilization ordinance registration, there's an online lookup. So these are things that you can find online. And if you can't find them online, you can do a public records request, and they'll give you whatever information they have.
Yeah, and then if you're wondering if it's a bootleg unit, you can go to the zoning department and talk to the zoning department to see how many units are supposed to be there. Or another trick is count the meters. If you've got meters that don't match the number of units there, then usually there's some shenanigans with unit mix, and you got to wonder. Okay, so we got about, what the heck? We're running out of time. I love this, you guys. So let's talk a minute or two kind of, I mean, Prop 33, it's business as usual, but business as usual, because Prop 33 didn't pass, business as usual doesn't mean that laws aren't going to change. So we're seeing in LA City, for example, they're removing more landlord rights and making things tougher. Where do you guys see things? You each get about 30 seconds. Where do you see things heading, Raphael, in next year or two for landlords?
Yeah, so one, Christian, is that substantial renovation thing that you're talking about, that LA City is no longer allowing it for properties who are subject to a just cause ordinance, which is basically at this point just single family homes and any other property built after 1979. I think that this one kind of makes sense why they are not allowing it anymore. We've seen success with this in court. However, both the judges and the juries don't really like this kind of don't like these cases. And honestly, your best bet for substantial renovation was to show up and say, look, I'm doing renovation in my property, and I want to essentially kick the tenant out, flip it, sell it, or raise the rent. And then if you're honest about it, it works, and we've seen it work. But that's pretty much the only way. If you're not upfront about what you're really doing, then kind of the judges and the jury don't really like that, and they can kind of step it out.
That's well said. I like that, and and then you got to follow through with it. So if you are going to do a substantial remodel, make sure it is substantial. You have to pull the permits ahead of time now and give them to the renter, but make sure you follow through. Make it a real project. Zach, what are you looking at? Where do you see things heading?
Yeah, same thing. I think that they're going to crack down on some of the more common loopholes. And then I think after that, yeah, it'll be every tenant getting a free attorney. And then maybe I think California, this election cycle kind of went further to the right. But the next time the pendulum swings and we come back around to the left, I think we'll see more regular rent relief. I think that eventually like regular rent relief programs of just the government will pay past due rent, that'll become something that we just live with.
And if I can, I'm showing you right now the eviction notices that are filed in LA City. They actually track them. And the number of rent evictions, as they call them, is a crazy tiny number. We're talking less than maybe 100. There is the vast majority, 99%, are for people who have missed rent. $650 million is owed in rent in what has been filed. That is the key to keeping people in their homes, eliminating the homeless problem. It's not going after rent evictions. I'm getting on my bully pulpit here. It is giving money, helping with back rent. So anyway, Kenny, you get to jump in now.
Yeah, just to add on, I'm definitely seeing probably the government is going to be providing attorneys for tenants in the near future, and that's probably going to be rolled out probably the next year or two. And then the rent relief, that's a huge thing that we didn't really talk too much about. But I've had many defense attorneys show up on cases that we've been prosecuting, and some of them are saying, well, I have about 3, 4, 5, 6, 7 different programs. I don't know which one is going to give me the money because I don't know which program has the money, but you need to apply to all of them and one of them will give it to you. Yeah, there's going to be a lot of programs out there that are either funded by the government, funded by private companies, private individuals. But that seems to be the trend where either the government or someone else is going to be looking to assist with the rent, and rent relief might just become this thing that kind of stays after the pandemic.
Okay, so if I'm out there and I realize I need an eviction attorney, why should I hire you guys? You're handsome, you're smart, but tell me why. Tell me why.
If you ever want to reach out to us, you'll reach one of us directly. You'll be able to talk to us. We actually will follow up with you directly. If you have any questions, a lot of the times when people call different law firms, they'll either get to a paralegal or someone that will take a message for us. One of us will be picking up the phone calls to be able to help you and answer questions directly that you have about your property. So I think that's if you have any questions, you'd rather want to talk to an attorney rather than someone else who's going to pass you along or maybe not pass you along to someone that knows what's going on.
And you guys have a new attorney who's joined, which we're going to have to bring into future live streams. And you continue to expand the team, which I appreciate. Raphael, why should I hire you?
Well, we care about our clients. We want to do right by them. We don't stiff them on the bill. We're very fair with them. When it comes to billing, we actually talk to them before we start sending them thousands of dollars. We win at every single case, no matter how big the client or how big the recurring, if it's a recurring client or if it's a one-time client, we always try to win every single case. And we're always improving our law firm, improving the brand. We're always talking to each other. We never put our egos ahead of trying to win a case. So yeah, give us a shot. And I think that you'll find that we have a much better product than our competition does.
Yeah, I love the synergy between you guys and how you all work so well together, complement each other. 1 + 1 + 1 is 5 with you guys. Zach, anything to add on why you do what you do?
Yeah, we've done thousands of these, gotten hundreds of people really good results, win more than 90% of the time, and still have the time to talk to people if they're going through it for the first time, take their questions, explain what's going on. You know, you just the way that I try and practice is the way that I would want somebody to do it with me. If it was, you're going to the dentist or you're getting your car in the shop, you sit down, you explain to people what's going on, what their options are, get them to a good result for an amount of money that they can live with, as fast as you possibly can. And, we've been really blessed to have customers, big and small, come back to us, and we're grateful to have their business. We're grateful they trust us with their business. So, just happy to get people good results.
Yeah, the golden rule of treat others the way you want to be treated, not he who has the gold rules. That one.
Exactly.
Treat others the way you want to be treated. Raphael, did you want to add something, bud?
Yes, this question right here, I really wanted to answer because it's a very common one. And
Oh,
he's
you got
asking,
it. Which one? Which one?
do I have to give them the option to move? I think
To love back in, to love
move
back
Yeah.
in.
renovations, but yeah, so you don't, and I think that's the reason why the city is no longer allowing us to do these evictions, because people can't comprehend the fact, like, wait a minute, I'm being evicted because you want to renovate the property that I'm living in. You know what I mean? So I don't think people really grasp like why we need to have this kind of an eviction. And I think now we just have demolition. So if you're gonna have to go down that route, you're just gonna have to demo the whole place and build a whole new house.
Yeah,
So-
demo's staying. They're just getting rid of the substantial remodel.
Yeah.
You can offer it to them at market rent to move back into. You don't have to match it.
It depends
guys
on your jurisdiction. So note that if you're like in San Francisco, you may have to let them move back in. Or if you're in LA under a tenant
All right,
habitability plan, you might have to let them
Yeah.
back in. So.
You guys do Antelope Valley?
Yes,
Okay,
it's very
cool.
close to us.
All right. I don't want to let you go. We're having so much fun, but you got to go. Raphael's got to take care of a baby, and Zach and Kenny have to do whatever they do after whatever time it is, 6:00. Thanks, you guys. I appreciate you being here. We actually have another one of these coming up. We have a couple more of these scheduled before the end of the year already on the calendar. So make sure you tune in. We will keep you apprised on when those will be. Keep your questions coming. Thanks for tuning in. And I can't wait to talk to you guys again. Raphael, wake up. Well, thank you guys for everything. Really appreciate you. Talk